Okay, we have our third case on the docket today. It's actually the fourth case of Ellerson and Moriarty and the law firm. Mr. Bradstreet, I believe you represent the appellant in this case. Is that correct?
Yes, Judge. Yes, sir.
Did you wish to reserve any time for rebuttal?
Yes, Your Honor. We would like to reserve 5 minutes, please.
Okay, thank you, sir. With that notation being made, you may proceed, counsel.
Thank you, Your Honor. May it please the court. I represent the plaintiff, the appellant, the plaintiff below, Erica Ellerson. The trial court erroneously dismissed Ms. Ellerson's legal malpractice case with prejudice, despite her pleading that she was a specifically identified and intended third-party beneficiary of the trust amendment that the defendant attorney drafted for her grandmother, Ms. Walther. In so dismissing her case, the trial court sidestepped this court's ruling in Passell versus Watts, a 2001 decision, 794, Southern 2nd, 651, and also ignored the 4th District Court of Appeals decision in Gunster versus McAdam, a 2007 case, 965, Southern 2nd, 182. Furthermore, the trial court took the defendant's invitation to create an additional pleading burden to impose upon third-party beneficiaries that seek to recover for the negligence of will and trust drafting attorneys. The elements of a legal malpractice.
I have a couple of procedural questions, if I might ask. I want to make sure I'm on the same page as counsel. This came to the trial court on a motion to dismiss. Is that correct?
Yes, it did. Yes, Judge.
That means for the purposes of the trial court's evaluation of the complaint, the trial court is required by law to take all allegations as true. Is that correct?
That is correct.
So the only question then is whether the plaintiff articulated a legal cause of action. Is that correct?
That is correct, Judge.
So if there was a deficiency in the pleading, then you should be given a right to amend.
Judge,
if there was a deficient, that'd be hypothetical. My concern is I read that the trial judge had multiple hearings here. And it looks like there was a number of factors brought to the trial court's attention that arguably are outside the scope of the rule. If that's the case, do we have any waiver of the rule? Because I'm not sure I saw any objections or anything like that. I want to make sure that I have, fairly evaluating the trial court's, handling of the case. Because there was 2 arguments, if I recall, the first one, and then you came back for a second one. And then I read his ruling, at the end of the second one. So there was a lot of process involved here on whether or not the pleading states a cause of action.
Yes, Judge, and we certainly in our motion practice pointed out to the court that it must take our allegations as true. And at the second hearing, after the trial court made its ruling, I reiterated to the trial court that we disagreed and that the trial court was drawing conclusions that this trust amendment did what it intended to do, was not negligently drafted, and we vehemently disagreed to the trial court's characterization of that.
Was there any challenge, though, to the trust? The challenge is the failure to fund the trust, the failure to create the quitclaim deed, to put this piece of property in the trust so that your client would have received it as the trust intended. But I'm not aware that there were any challenges to the trust itself.
Right. There was no judicial challenge to the trust because there was absolutely no property within the corpus of the trust.
Well, but I think that was maybe Judge Nicholas's point, that the trust did what it was intended to do, and no one made an argument to the contrary. The argument was, but the lawyer should have taken the next step, prepared a deed, transfer the property to the trust. Am I right about that, or am I missing something?
Judge, we certainly argued that the trust did not do what it intended to do because the trust did not actually convey the property to Ms. Ellerson.
Again, your problem is the failure to prepare a deed conveying the property.
Either a deed, or a
problem with the trust. Your issue is he didn't take the next step.
That is correct, Judge. Either a deed or a pour-over will.
Okay, let's go to Passell a minute. You raised our case in Passell, and you said that pretty much Judge Nicholas ignored Passell. Well, Passell was a challenge to an invalidly prepared trust, wasn't it?
The language of Passel discusses that the trust was invalid, but it was invalid in light of an earlier original trust. And our point is that in and of itself, there is no indication in Passel that the language of the trust amendment that was at issue was done incorrectly or ambiguous. It was just, it could not be done through an amendment because of the original trust, which we think is exactly the point here, is that this amendment did absolutely nothing in light of the title to the property.
Hang on. In Passel, the problem was with the structure of the trust, not the failure to take a next step, because these are very important differences, because these trusts are prepared all over the country in every jurisdiction. And certainly there has to have been failures to fund trusts other than this one, because that's what this is. This is a failure to fund a trust, not a failure in drafting a trust. Passel was a failure in drafting a trust, not a failure to fund the trust. That's why Passel doesn't control in this situation. And it's hard for me to believe that in the 50 states where there are living trusts prepared by probate and estate planning lawyers all over the country, there isn't a case dealing with a failure to fund. And neither one of you found one.
Judge, there is a case dealing with a failure to fund, and that would be the Gunster versus McAdam case, the 4th District Court of Appeal case from 2007. And in that case, the second issue was that the trial court did not err in submitting to the jury the question of whether Gunster Yoakley had a duty to fund a revocable trust.
Well, but the issue in that case is they had agreed to do so. Now, the question in this case is, there have been some allegations that this lawyer agreed to prepare this deed. And it was not clear to me that that was really persuasive evidence, and there was a lot of problems with that evidence. So why don't you walk me through that again and try to convince me that this lawyer agreed to prepare this deed to fund this trust?
And again, Judge, we are obviously, we're at a motion to dismiss, and she made the allegations. One, that Moriarty met with the grandmother both inside and outside of Miss Ellerson's presence. That would be paragraph 14 of our complaint. Moriarty did not properly limit the scope to exclude advisory services related to funding. That would be paragraph 15. And then
Before you leave paragraph 15,
so hang on,
I have a
let's stop
question.
there.
Whose duty is it to define the scope of the engagement, the client or the lawyer?
Well, in a case where the lawyer is the expert, we think it would be the lawyer. And obviously, this is why this isn't appropriate for a motion to dismiss. This goes into what is Miss Walthor's age, what is her educational background, what experience does she have with legal matters, and that goes well beyond the allegations of the complaint. But more importantly, paragraph 17, it's alleged that he failed to draft and record the deeds despite conversations with both Walthor and Miss Ellerson, in which he represented he would be filing deeds. And so the point of the defendants that the trial court.
So those allegations have to be taken as true, correct? For purposes of the motion.
That is correct.
Paragraph 17 is the only one that's got my attention. I'm not persuaded by 14 and earlier reference, but 17, that may be a significant problem.
Right, Judge. And the reason that the defendants prevailed upon the court to ignore that was because they went a step further in the Lorraine, Passel, Gunster line of cases to say, oh no, that the scope has to also be within the trust amendment. So basically, since the only document that was signed was the trust amendment, they're saying that we can't bring any extrinsic evidence at all in, including in the pleadings. Our point is that when you look at Damaris, when you look at Passel, when you look at Dingle, all of those cases, the issue is whether or not the intent expressed in the trust agreement or the trust amendment was expressed. And that was certainly expressed. The intrinsic evidence of the trust agreement was that Miss Ellerson is supposed to get this property. And so we think that's the outer bounds of what is required to be intrinsic evidence. But it goes further in the Gunster case, because the Gunster case actually cites to Lane v. Cold, 882 Southern 2nd 436, a first DCA case, and basically states that A duty, such as a duty to fund a trust, can be an implicit agreement by the attorney. And so we certainly believe that because of paragraph 17, that we stated a cause of action within the four corners of the complaint. But even without paragraph 17, we believe that this attorney drafting a trust amendment that purports to give Miss Ellerson 100% of the 17th Street property, at the very least takes on an implicit duty to make sure that it's actually going to be effective. And, you know, the defendants in their answer brief bring up a whole bunch of, you know, what ifs and speculation and things outside the four corners. Well, maybe Miss Walthor, you know, only drafted the trust amendment to placate Miss Ellerson, or maybe she, you know, purposely didn't fund it, and things like that. And, you know, if we're looking at intrinsic evidence, it's the intrinsic evidence is that she intended that my client get this property. The trust was never funded. Ergo, my client got just a portion of the property under the intestacy rules. So, you know, the third party beneficiary standing, you know, does apply primarily in will and trust drafting cases, but it has been expanded to other contexts, such as the Dingle versus Dellinger case, which was cited. And the reason we think that case is important is because it is very similar to the case here. In that case, the lawyer was drafting basically a quitclaim deed for a piece of property, I believe in Argentina or Panama, somewhere in South or Central America. And it had to do with there was a power of attorney drafted by somebody else. And because of the power of attorney, the quitclaim deed wasn't effective. And we think this is the same thing. This trust was not effective because of the title of the assets. And
well, the only problem with Dingle in this case, again, no one has challenged that the trust was improperly drawn. And that's what Dingle was all about. The quitclaim deed was improperly drawn and executed. Those aren't the allegations here. It's a separate issue, and it's an important issue given the large number of these trusts, as I've said, and this type of issue. This is a failure to fund issue. This is not a failure to draft issue. So I respectfully disagree. I don't think Dingle applies. Gunster applies, and that first DCA case, Cole, I think, applies, but Dingle, no.
Right.
And Purcell, no.
Well, Judge, I would say about Purcell, although the trust amendment wasn't effective in light of a previous trust agreement, the important thing to remember about Purcell is basically talking about a lawyer's duty. Here, the lawyer, despite this other case in Lorraine, had a duty to do some other action if it would have resulted in the beneficiary getting the devise. And
see, what's also troublesome about this facts of this case is this lawyer wasn't the estate planning lawyer. This lawyer wasn't the one who sort of had the overall plan and was involved. That lawyer is out of the picture. This lawyer is brought in for one narrow issue: prepare this amendment to address this property and the granddaughter. And that also makes this very different in terms of what really did this lawyer sign on for. Okay.
And I understand that, Your Honor, but you know, we also alleged in paragraph 10 that he was retained for certain estate planning work. Now, the estate planning work that failed, that did not actually go through, had to do with this trust amendment that was part of that work.
And there's no question those allegations have to be taken as true for purposes of the motion to dismiss. So you have my attention on that.
And so our point being that, you know, again, it goes to, and I foresee that the defendants will argue, well, Judge, whatever was said between Ms. Walthor and Mr. Moriarty, or whether this conversation occurred about filing the deeds, that's all extrinsic to the trust agreement. And we go back to the idea that the rule isn't, you know, everything has to be intrinsic to the trust agreement. The rule is that the intent of the testator must be intrinsic. And it's clear from our allegations that Ms. Walthor's intent was that Ms. Ellerson get the 17th Street property. And so, and that's why we are allowed
Counsel,
to make.
Before we get to 15 minutes, I'd like to ask you a question regarding on the pleadings. And since you are, I'm sure, do a lot more of the probate work than I do, this is my opportunity, in a sense, to pick your brains. As I look at the contents of the paragraphs going to paragraph 17, the argument is a third-party beneficiary of the contract. Is that correct? Now, does that concept of third-party beneficiary segue or apply to paragraphs 18 and 19, which seems to suggest a duty of care and negligence?
Right. Well, we believe that in the case law is that
Well, there's an additional duty here in 18 and 19, right? He should have contacted somebody else. I'm not certain, does that flow as a result of a breach of a third-party beneficiary contract or as a separate individual tort that is a breach of a duty of care?
well,
And are these concepts commingled in this area?
I believe they're commingled, Your Honor, and the reason being is that lawyers may be sued by non-clients for fraud and things like that. But when you're talking about negligence or a standard of care, the case law is either their client or the third-party beneficiary of their services. And most of the
third-party beneficiary usually is a term of art we use in contract law.
Right.
And so, you breached my contract to specifically perform this duty, and as a consequence, I have suffered damages. Then for negligence, you have to have a duty of care that the law recognizes. And in this case, they are not the attorney for the third-party beneficiary. They're the third attorney for someone else. And I'm wondering how that comes about. And maybe that it's too early in the pleadings, but I just noticed it seemed to me that there was a segue there with the word additionally there. We were moving to a different theory, but I don't want to take up your time, so I'm going to stop, preserve your 5 minutes, and we'll move over to the appellee's argument at this time. Okay, I've cleared the timekeeper, counsel, so you haven't lost anything, and I would remind you that your microphone is muted. You may want to make sure we make that go away.
There we go.
You are now audible.
Now,
Thank you.
Thank you. May it please the court. My name is Michael McGurney, and I represent the appellees, Mr. Moriarty and his law firm. What we're talking about here is not whether it was improper of the court to dismiss the claim at the motion to dismiss stage. What we're talking here is about the plaintiff's attempt, the appellant's attempt to expand the duty of lawyers to non-parties. The law is clear and has been clear for years that in order to sue a lawyer for malpractice, you have to have an attorney-client relationship and privity of contract. The exception, the lone exception, has been for years that in a will drafting or trust drafting arrangement, a beneficiary, now I'm not using the term third-party beneficiary, I'm just saying beneficiary of the trust or the will can bring an action against the attorney if in fact his conduct in drafting that will or trust frustrated the testator's intent. And the testator's intent is determined intrinsically versus extrinsically, because there's no way in a will drafting situation or an estate situation, we would have to deal with basically people saying, well, grandma told me this, or dad told me this, and why isn't that in the will, or why isn't that in the trust? The rule is in place, that the law is in place for a very simple reason, because lawyers would then be liable to everybody, every beneficiary, every heir to an estate. That would be a problem, because then you have to then go surmise what's going to happen. And in this case,
Or you'll be subject to suit by everybody.
yes, and that's the whole point. You're opening the door to all these lawsuits. It's very, very clear. If the lawyer screws up in drafting the trust agreement or the will, then the beneficiary who is going to derive a benefit from that can bring a malpractice action, only that way. In this case, the appellant wants to A, expand that duty, and B, bring in extrinsic evidence, which it's not allowed to do under the law.
Well, let's talk about Gunster then. How do you reconcile Gunster?
Well, Gunster is a whole different set of facts as far as I understand. It's not the situation. We have a situation here where they drafted the trust. And as you said, he wasn't the estate lawyer. He drafted this amendment to the trust. That's it. He doesn't know. And quite frankly, in these kinds of situations, many times, the person who's supposed to fund a trust changes their mind, doesn't fund a trust, that it removes the corpus of the trust.
Well, we don't have those facts before us. What we have is a complaint that's made allegations which have to be taken as true for purposes of a motion to dismiss.
No
and-
question, Judge. No question.
And basically the paragraph 17 of the complaint says the scope of this lawyer's duty was to fund the trust. And now whether that's true or not, that's subject to, an evidentiary hearing down the road. But that's the allegation, and that has to be taken as true for the motion to dismiss, right?
Perhaps, but let me explain to you why it shouldn't, okay? Part of the reason that the judge, and the judge was very careful here, the 2 hearings, what he did, he had a first hearing, and he said, I'm looking at the law, I want more, I want you to look outside the state of Florida and see what else you can come up with, and we did. And the law is pretty consistent about whether or not there is a duty. The issue is not necessarily.
Well, they've alleged an agreement, which now creates a duty. Again, it's an allegation, hasn't been proven. We'll never know if it's be proven or not as we sit here today, but they alleged it. And it has to be taken as true for a motion to dismiss.
But in a context of determining whether a lawyer can be sued for malpractice, there has to be an establishment of a duty, and there has to be the exception to the law in terms of privity of contract. And I apologize, this shouldn't have happened.
I thought it was mine.
And we're all looking around.
I was grabbing my phone, like, how could that happen?
It's unbelievable. Anyway, you're saying that the lawyer had a duty. The law is very clear. The duty is very.
Here's what I'm saying. I'm not saying the lawyer had a duty. I'm saying they have alleged that he accepted the duty. And for purposes of a motion to dismiss, we have to assume that is true.
Okay, well, then the question I have is, how's that established? Because quite frankly, she's not a client. How does she determine, get past?
That's all for an evidentiary hearing. That's all your proof. That's all your defense. I mean,
Right.
but that isn't what, at a motion to dismiss, you're not in an evidentiary hearing.
That's correct.
So
The question that we're looking
that's
at
where
is,
I'm stumbling here. So you got to help me
has
get over
the
that hurdle if
plaintiff-
you want to prevail.
has the plaintiff articulated a legal cause of action? If the plaintiff's allegations don't fit in with what you assert is the law to have a cause of action, then they fail to plead it. And we could say, yeah, the case is not properly pled. Go back and see if you can amend your pleadings. If you can't amend them, then we would say this is not a cause of action that Florida law recognizes. But to do that, we have to take the allegations as true, as Judge Morris put out. So that's why I was asking the first questions, what is the law in Florida? Does this track the law in Florida? If it doesn't track the law in Florida, where does it fail? You've argued this is an expansion of the law in Florida.
Correct. And not only that, it's requiring, I understand what Judge Morris was saying in terms of what's pled and having to take it as true. But if what's pled is extrinsic and the law says you can't look at extrinsic evidence outside of that drafted document, and that's what the law says. So if it's extrinsic, it shouldn't be even allowed. It can't be allowed. So you can't circumvent a motion to dismiss by pleading extrinsic evidence to establish some type of fact that needs to be determined through evidentiary hearings, discovery, whatever. There's no.
So it sounds like your position is, in order for the granddaughter to prevail in this case, she would need to have hired your client specifically to prepare the deed.
Yet number one, yes. Yes.
I mean, most beneficiaries don't know they're named in a testamentary instrument.
I'm sorry, John?
Most beneficiaries don't even know that they're named in a testamentary instrument.
That's
So
correct.
how, I mean, you're putting a burden now on a beneficiary, which the vast majority of them wouldn't even be aware that they had a dog in the fight.
Well, the beneficiary can't hire the lawyer for the testator because there would be a conflict of interest. Can you imagine if every beneficiary could then turn around and say, I'm hiring you to do this contrary to what the testator's saying?
Well, hang on. We have these trusts all over the country. I mean, it's a cottage industry for estate planning lawyers. They love preparing these living trusts. It's a big deal. And what you're telling me is that that's all they got to do is just prepare the trust. And hey, don't fund it. I mean, that's somebody else's problem. Go take that elsewhere. I don't do deeds. I don't transfer stock accounts, rename them. I don't do that. It's up to you. Is that what you're saying?
Yes, if the lawyer is hired to draft a trust, he did
And
not
that's the end of it.
have any other duty. He does not have a duty to fund a trust or to make sure.
Even if he agrees.
If he agreed, that's a different story. But
It's
that's
been
not
alleged that he agreed. Paragraph 17 of the complaint.
they're alleging based on extrinsic evidence. See, the problem with the will draft or the trust draft is it's very clear in the law that the only way a beneficiary can get past the privity requirement is by looking at the document itself. And they themselves, it's not a judgment by the court, they themselves pled that there was no error in the trust document.
I'm pretty persuaded that no one has claimed that there is. Even, Mr. Bradstreet tried to, take some position on that, but I'm persuaded that nobody's finding fault with the trust amendment. The sole fault is to fund it. That's the. But let's go to the extrinsic evidence. So give me an example of the evidence that would be needed to show that your client assumed the duty to fund the trust. What kind of evidence you've taught? Use the word extrinsic. Give me an example of non-extrinsic evidence.
Intrinsic evidence
in this situation
would be what's in the document itself.
So the document itself would have to say, after that she's going to be the beneficiary of the transfer of this property, the document itself is going to say, and lawyer so-and-so is going to prepare the deed?
Correct.
Well, nobody does that.
Well, that's right. And that's why the law is the way it is because it's extrinsic versus intrinsic. Intrinsic, you look at that document, and if the lawyer messed it up, then he's got a problem. But in this case, that didn't happen. What they're looking for is, oh, by the way, he agreed to do this and do that. We don't know whether he agreed or he didn't. The only way you can establish
but that's a subject of an evidentiary hearing.
Yes, but Judge, I understand what you're saying, but the deal here is the duty. That when you're stating a duty in the complaint for suing a lawyer for malpractice, there has to be a basis to do that. And if you're saying that the only way I can prove it is through extrinsic evidence, that's not the law in Florida. The law in Florida for suing a lawyer who drafts a trust or a will is it has to.
Give me your best case that says that again.
Pardon me?
What's your best case that says that?
Well, we go into Lorraine and the cases we've cited in our reply brief. There's a whole slew of them. Lorraine versus Grover, I don't think
Okay.
applies. There's also the Angel Oberon case in terms of the duty issue and so on. There's a whole slew of cases in our reply brief, and we'll rely on them.
Okay.
But Judge, it's pretty clear, and it has been clear for over 30 years that I've been practicing, that in order to sue a lawyer for drafting a defective document or a defective will or trust, there has to be intrinsic versus extrinsic evidence. And that's number one. Number two, now what you're doing is saying, okay, they can assert a duty in this complaint by saying, oh, the lawyer also has to do these things. What he's arguing is an extension of the duties. And quite frankly, that's problematic for lawyers.
But what you're arguing is that no lawyer is ever going to be responsible for failing to fund a trust unless that lawyer's duty is specifically spelled out in the trust.
Not true.
Okay, help me with that.
They held responsible. If the plaintiff in this case was the personal representative of the estate and said, hey, you messed this up, that's different than a beneficiary suing the lawyer as opposed to the personal representative suing the lawyer. That's two totally different issues. And in that case, if it's a personal representative, they can sue and hold the lawyer responsible for any errors he made in addition to drafting the document.
The same would be the case for a trustee, right?
Yes.
Okay. And in this case, there is a trustee, and that trustee has been silent.
I'm sorry?
The trustee in this case has been silent on this issue.
Yes. There's no action by the personal representative or the trustee. None.
Okay.
Counsel, let me ask you
This action, we wouldn't be here today.
Let me ask you this question about counsel's duty. Client comes in, advises client lawyer, I want to create a trust amendment to my trust so that my granddaughter, whoever, gets this property. At that point, in the engagement process, doesn't the lawyer have some duty to say, understand this is only the first step of the process? If you do this, you have to take another step and hire someone to do a deed. Otherwise, you've done it. Otherwise, you're going to take a service to do something without full information to the client.
Well, perhaps, Judge, but there's no allegation that that's the case here.
Well, that may be correct in a specific, but as I look through, was it paragraph 15, where there's a second line there about excluding advice. And I wondered if that pleading in the second line of paragraph 15, that terminology would encompass the hypothetical I just posed to you.
I can't answer that, Judge.
Okay, fair enough. You know, I'm working through the documents. I was, you know, making sure that I'm trying to make sure I understand all this stuff.
Right. Well, this is part of the problem here, and I'm certainly not a trust lawyer. I'm a malpractice lawyer. To me, in order to do what they want you to do, it requires a lot of assumptions and a lot of extrinsic evidence and a lot of things that are not allowed by the law. And the judge was correct. In fact, the trial court judge, when he looked in the second hearing, said, I don't believe there's a duty here, but I don't want to get into a situation where I'm the one deciding the expansion.
He didn't want to be first in his neighborhood.
Yeah, he didn't want to be the first.
Yeah. I read that part of the transcript. That was I reminded myself of being a trial judge, and I thought, oh, I understand that thought process.
Right. So I think that was his rationale and that was his thinking. And quite frankly, I believe he was correct. So the appellees argue that in order for this to be overturned, there has to be assumptions and changing of the law, expanding of the law for lawyers who are in this kind of situation.
I want to go back for a second to something that you responded to Judge Morris with regard to whether there were stock certificates, or let's say it was a title to a vehicle. There was something else that was funding the trust. In this situation, where that wouldn't be something that you would ordinarily expect that the attorney would do, to go down to the state and have a title transferred over, versus here where there's deeds that you would expect that some attorney, I mean, although somebody could do it themselves with a quitclaim deed. So I guess where I'm on the fence and looking at this issue is, should there have reasonably been something stating that this attorney had an expectation to draft a deed? And what are you pointing to for us to look at that they had no responsibility?
Well, first of all, your judge, the fact that there was no issue of this in the complaint or whatever, there's nothing drafted. And to expand the duty for the lawyer, there's nothing in there to indicate that's what he was asked to do. Plus, there was a prior comment made by, I believe, one of you, that the way that there was a prior lawyer involved in drafting. We drafted an amendment to a trust, not a trust. So there was a prior lawyer involved. So then we get into this game of it. Do we impute an assumption on the lawyer that this was done properly by other lawyers, or that it should be done by someone else, or he has a responsibility? Who has a duty? We know that he was asked to draft this amendment, and he did so, and it was not defective. If something else happened, so let's expand what take your question, Judge, and expand it even further. Let's say he makes a phone call and he finds out that the deed is there. But what if the deed's defective? Does he have an obligation to make sure that the deed's not defective, or does he have a responsibility to do other things, to fund things? That's, once again, now you're going down this slippery slope of expanding the duty of lawyers. And it's hard enough to be a lawyer in Florida anyway, with all the duties that we have, but that now to expand the duty to say, okay, you lawyer not only have an obligation to your client who hired you, but you have an obligation to everybody that's benefiting from it, who's a third-party beneficiary, who's an heir in the will. And even though there's someone else handling the estate, you in fact have that obligation. That's going to open the door to a massive amount of litigation and appeals, I might add. And
so that I'm clear on your position, that if this were the PR or trustee saying you should have moved forward to move a vehicle, or you should have had the stock transferred, or you should have drafted a deed, then they would proceed to the next step. But because this is a third-party beneficiary in this situation and there's no duty, therefore it fails completely and a motion to dismiss is appropriate.
That's correct, Judge. That's my position, our position. Okay, so it's our position that this appeal should be dismissed and the lower court ruling should be affirmed. Thank you.
Thank you, counsel.
Thank you, Your Honors. I would like to get back to the court's question about the third-party beneficiary and how that the contract.
You know what I think, Mr. Bradstreet? I don't mean to cut you short. I know you have something you want to say, but you might want to address this extrinsic, intrinsic evidence issue, because that's where this is really sitting on the fulcrum.
Yes, Your Honor. And actually, the third-party beneficiary argument gets into that because
Go
the
ahead.
point
Okay.
is that there must be intrinsic evidence in the drafted instrument that the that the client, the testator, intended to benefit that particular plaintiff. And that's what prevents the this expansion of liability that Mr. McGurty is concerned about.
Yeah, but the whole
that-
thing is whether or not the lawyer in our case assumed the duty to fund the trust or not. And that's
Right.
what has to be proved with intrinsic evidence only.
Well, what has to be improved with intrinsic evidence, according to all the case law, is that Miss Ellerson was a intended beneficiary. Whether the scope was to draft a second document and that sort of thing, that doesn't have to be proved solely by intrinsic evidence. The duty to a particular plaintiff is what is a duty to not be negligent to both the testator and any intended third-party beneficiaries. That is what is established by intrinsic evidence.
In a sense, the intrinsic evidence, by looking at the document, specifically identifies the third-party beneficiary, thereby affording them standing to institute suit.
Yes, Judge, that's exactly what right. And the court asked Mr. McGurney, what are some examples of the non-intrinsic evidence that wouldn't be allowed? And in the response that opposing counsel gave, it tends to make it impossible. Basically, like the court pointed out, nobody says I intend that Miss Ellerson get 100% of the 17th Street property, and my attorney is going to make sure that there's deeds to do that. Nobody does that. This creates a virtual immunity to third-party claims. And we go back to Gunster, where implicitly the attorney agreed to fund it. If it's implicit, it certainly isn't, that trust agreement didn't say, something to the effect of that the attorney's going to fund it, because it was implicit in the documents that he did. Counsel discussed or pointed out Lorraine and Angel, and the point of Lorraine isn't that that all the duty must be intrinsic. It's just that, is there a duty to this particular beneficiary? Lorraine failed due to causation, because the homestead could not be devised by will or trust or any other way, because there's a constitution and a statute that says how you pass homestead. And to the questions about the PR or trustee bringing the claim, if this were a situation where, the residual to the estate was diminished or something like that, then the PR arguably would have been damaged, or the trustee arguably would have been damaged in capacity of trustee. The situation we have here is that the person who's been damaged is the intended third-party beneficiary, and that's who, has standing because she was a third-party beneficiary, and that's who has been damaged, so can, bring to try to recompense the 17th Street property or the value thereof. If this were a tax issue or something like that, then perhaps the trustee or PR should have brought it, because the whole pot gets diminished by taxes and that sort of thing that arguably the lawyer didn't do correctly. But we're talking about a specific devise that didn't go through because what we allege is negligence of the lawyer. And so that is, that's the intrinsic evidence. And in the cases throughout the country that opposing counsel brought to the court, those are kind of like Espinoza, where there's
Let me take you back to the intrinsic evidence argument, since you've said we look to the document in order to look to who would have the standing as a third-party beneficiary. Conspicuously in paragraph 18 or 19, There's no such pleading with regard to the alleged duty, that it flows from an extrinsic document that we can look to it. And wouldn't that be just a duty owed to the decedent if it was breached because of privity of contract?
Well, the duty to the decedent is what's intrinsic in the trust agreement. And that is that Miss Ellerson, takes the 17th Street property. We believe that, 18 and 17 certainly
18,
stated,
19.
yeah, right. Excuse me. Thank you, Judge.
Said he failed to draft a new pour over, failed to do. I'm trying to see how that flows from the intrinsic evidence, that is to make sure that this trust is either properly funded or advised what you need to make it operational as compared to 18 and 19. That seems to be more realistically a duty that was owed to the decedent.
But it absolutely benefits the decedent none, because the decedent is deceased by the time that actually benefits anybody. And the point being, again,
Well, then the
Judge, is that-
PR would step into the shoes, right?
well, to the extent that the estate as a whole was damaged or there's some residuary, but here we're talking about a specific piece of property. And again, the intrinsic evidence is provided in the trust agreement. The intrinsic evidence is that Miss Ellerson take this property. And if we look at the language from Damaris, which, Damaris is cited by Espinosa and all these other cases,
I'm going to
liability.
need to ask you to sum up in about 15 seconds since we've gone a little bit
Yes.
beyond 5.
Yes, Judge. So the liability to the testimony beneficiary can arise only if, due to the professional negligence, the testamentary intent as expressed in the will or as expressed in the trust was frustrated. We believe that we've expressed her intent in the pleadings and also other additional allegations once she's in that intent that we can bring. And we ask that this court reverse and remand for further proceedings in the trial court. Thank you.
Thank you. Thank you
Good
both.
argument.
Well presented, and stay well, gentlemen.
Thank you,
know,
Judge.
We thank you. At this time, for those who are listening, it's I think about 11:08, 11:09. We're going to take about a 10-minute break, and then we'll come back.